Just as there are 5 stages of grief, they say there are 6 stages of divorce. Divorce is traumatic for everyone around, even the family. First is the emotional divorce, which is the loss of trust, respect and affection by the partners. During this stage, usually instead of supporting each other or trying to separate with little damage, the spouses tend to react violently or aggressively with each other, and they like to frustrate and diminish their self-esteem. The husband and both sense that the marriage is deteriorating, and they both stress on the negatives rather than the positives. This is emotionally draining. Bitterness from failure, dissatisfaction, this is what all comes together and erodes the relationship completely. At this stage, couples often look outwards for satisfaction, and either party or both may indulge in extramarital relationships, which only makes things worse. Next is the legal divorce. This is when they've got past their fighting, they've understood we are going to fight, and they do not want to be in the marriage any longer. So they approach the court, a lawyer is engaged, or they go to the family court. Legal situation is the official beginning of the official end of the marriage. The judges are always, this is important, judges are always the unnamed third party in a divorce proceeding. A judge's role is to separate the wheat from the chaff, to find out what is really going on, and instead of increasing hostilities, try to bring down the hostilities which are escalating and come to a solution. Not every marriage can be saved, not every relationship can be saved, but it is the duty of the judges to attempt to at least make people part in an amicable manner. Each spouse tries to protect their own interest, especially if there are lawyers involved. I'm sure you've seen that a lot. The interests are generally financial or material. This is where structured mediation or sending people to mediation comes into use. So we have mediators, we have a mediation forum. It has the potential to provide the couples with an alternative to resolve their conflicts and come to a decision. Under Section 9 of the Family Courts Act, there is a stress on the importance of judges trying to come to a settlement. But this is not always the case. Judges have full lists. It's not practical that the time given as a lawyer who also does divorce matters, sometimes in divorce cases these conferences, they go on for hours because you end up counseling the client more than actually talking about the law or what steps they can take. So you can't expect judges, one cannot expect judges with a busy schedule or a huge roster to actually sit and spend the time that is required for this. There are many factors to be considered. Most lawyers dealing with matrimonial cases have some funny story or other to tell. Most lawyers and judges. For instance, take the COVID lockdown. There's a quote by Natasha Kulena. A divorce was invented so you'll not have to sleep with a mistake for your entire life. Some people took this literally during the COVID. Couples were so forced to stay together in one place together that they woke up one morning and decided, no, I can't live like this. You really won't believe that the amount of divorce cases that grew after the COVID. In any case. And it becomes worse because you have well-wishers, you have lawyers, you have advisors, you have family members who are always trying to help and end up doing the opposite. Next is the economic divorce. That is the division of property, assets, maintenance, alimony, child support. This is sometimes the most important part. It is in this stage that most of the arguing, frustration occurs. The lawyers often negotiate and resort to adversary proceedings. This is where they start fighting. The economic divorce is difficult for 3 reasons. 1, no one feels they are getting their full share. 2, arguing about who will get what. I won the house, you won the car, I paid more. And a sense of loss when each party realizes that now they are without the other half of their home. Because really speaking, we are dividing everyone. A judge or mediator or even a lawyer involved in negotiating a property settlement has to appreciate also that material possessions are not just because of the value of it, but also because of sentiment attached to it. Be it a flower vase, or a hand sanitizer, or a bag, or a house, a car. I might have bought it with my own hard-earned money. Why will I give it to you? So maybe even a song, intangible assets, a CD. I bought it at this stage of my life. I was so in love with you. So it is important to understand that not everything, all material possessions might have sentimental value, and it has to be handled sensitively. This entails consideration of factors other than economic, be it a car, house, whatever. Here, partners may also have a sense of entitlement. The husband may think, look, I've been working, I've been earning, everything is mine. The wife may think, I've sacrificed my career, I've given up everything to be here today and not earn. So everything is mine, I am entitled, I raise the children. This kind of dispute goes on and on. So there is a stage when the judge or mediator has to come to a common ground and find out what it is. You have to think of it as an important business project. You don't always love a person that you're working with, but you have to work together to get the work done, that project done. Co-parenting is just that, and that's the next stage. Co-parent. Co-parenting is for those who have children, which is concerned with problems that arise with custody determination. This is brutally painful, usually, most of all for the children. The concept of co-parenting is that while the divorce terminates the legal bounds of the matrimony, it does not terminate the child-parent relationship. This battle over custody, visitation rights, child maintenance, and continuing parental responsibility is often entwined with economic divorce, naturally. And this also proves a lot of ground for manipulation and retaliation from spouses. The mother might deny the father visitation, the father might be unkind to the mother, which the child will see, or vice versa. And whoever has custody of the child, unfortunately, usually tutors the child. If I, as a child, see my mother constantly telling me that my father is evil, I will obviously be frightened of him. And so this is the stage where the most important factor comes in, that is the best interest of the child. It is the duty of the courts, the judges, and even the lawyers to a very large extent, to not increase the acrimony between the parties, but look at the welfare of the children. It is a critical factor in avoiding primary custody, should be with the parent who is better able to permit the non-custodial parent to interact and have a healthy relationship with the child. Understand that the person who has custody should be the person who will be willing to allow the child to interact with the other parent. My differences with my husband should be kept aside. Husband should have access to the child, or vice versa. Next is a community divorce, where each partner leaves the community of friends, relatives, to avoid uncomfortable situations. Because members of one social group usually tend to attach themselves to one party of a divorce. You will notice friends, relatives, they go to one party, either party. Usually, so one party feels abandoned, the other party has a sense of loss. The party that is not abandoned may go to a gathering of married couples and feel a little left out. So this social acclimatization takes time. This is all going on in your mind as you are going through a divorce. This new singlehood, particularly if you're older or have been married for a long time, takes a while to adjust to. The death of the marriage is in many ways worse than the death of a spouse. Death of a spouse is tangible, but the death of a marriage, being intangible, is more difficult to recover from. Finally is the psychic divorce. This takes a while to happen. This is where acceptance comes in. When people accept that yes, this is final and most crucial separation in the divorce, the stage when the problem of gaining autonomy is first confronted, then accepted, and the partner realizes that she or he is an individual and henceforth will be the sole person taking decisions in his or her life. It requires a lot of strength and is essential for the emotional and mental well-being of the person. One cannot come to this stage of acceptance. It requires self-confidence, resiliency, and this is possible once you have recovered from the trauma of the divorce. At some point, the person also regains the capacity to maturely deal with the demand of life and maybe even enter into other emotional commitments. This is similar to a breakup. Even a living relationship, when it breaks up, it's the same. It may not have the legalese of a divorce, but every breakup brings its own emotional requirements. Eleanor Roosevelt, the famous lady, said, "It's better to light a candle than curse the darkness." And that is where the candle is lit. That is where the darkness leaves. So this is the segment about the psychology of a divorce. Any questions, anyone? Anyone? Thanks. Shall we move on to the next session? Yes. So that too. Role of judges in divorce maintenance, custody and guardianship. Shall we start with the custody of a child? Because that is usually the most important, because we have to look after our children. After all, we are leaving this world for them. All the institutions and courts involved in the process of divorce must, first and foremost, take care of the children's benefit and well-being. The welfare of the child, as we all know, is a priority for the courts and also the parents, mostly the parents. It is the duty of the courts to motivate the parents to communicate and cooperate for the welfare of the child. The parents need to be more sensible, more responsive for their children's emotions and needs. Parents that are together handle their stress. When they separate, they have to be more conscious of the needs of the child. Because the needs of the child change after their parents separate or divorce. They have more questions, more emotional requirements. For example, do they still love me? Can I love both of them? How will it be in the future? Can I tell my mother I love my father? Can I say I want to go out? Will she be happy? Will she be unhappy? Will she judge me? Children go through these conflicts all the time. Children need the affirmation of the love of both parents and the security of both parents. Most children, if you see in custody matters, if you ask them, they're frightened. They don't know. They love both parents. They interacted with both. Just because they are fighting, they're confused. The most important people in their lives are fighting. You're just confusing the children. The Supreme Court in this case, in Vivek Singh versus Romani Singh, reported in 2017, Volume 3, SCC 231, has discussed a term called parental alienation syndrome. In paragraph 18, it has citation is 2017 volume 3 SCC 231. Vivek Singh versus Romani Singh. What they call the parental alienation syndrome, which has two psychological destructive effects. One, it puts the child squarely in the middle of a contest of loyalty, a contest which cannot possibly be won. The child is asked to choose who is the preferred parent. No matter what the choice is, the child is very likely to end up feeling painfully guilty and confused. This is because in the overwhelming majority of cases, what the child wants and needs is to continue a relationship with each parent as independent as possible from their own conflicts. This is one. The second part is the child is required to make a shift in assessing reality. One parent is presented as being totally to blame for all the problems and as someone who is devoid of any positive characteristics. Both of these assertions represent one parent's distortions of reality. Understandably, the single biggest predictor of a poor outcome, this is outside the judgment, is the continuing conflict of parents. Despite their intense emotions, parents need to recognize and satisfy their children's need. They need to observe the children's emotions and pay attention. And that is something that judges can aspire to do, because it is difficult for parents to actually come to a situation where there is a non-acrimonious custody. There are some cases. I know of couples who parted on very friendly terms. They happily took care of the children, decided, but it's rare. As judges, you will know usually it's a big fight.
Ma'am, if I could kindly interject in this, because I am facing with this issue right now with
Yes.
regard to the custody only, the topic which you touched, and here we are all family court judges. If I could get any suggestions from you all. There's a case pending before me. These two couples, they have a case pending before me. The husband wants a divorce from the wife. Ground is cruelty. Okay. Now again, the husband has filed another case before me, that is for custody of the child. The assertion of the husband is, in cruelty as well as in custody of the child, is that the wife is an alcoholic. Okay. and he's submitted everything, the evidence documents to say that she has went to a rehabilitation center and she is not capable of looking after the child, years old. And the boy is 9 years old. Now I do not know what will I do, but then I was just faced with the situation. In their, as per the Family Courts Act, I have sent them for counseling. The divorce case has also gone for counseling and the custody is also gone for counseling. But what I have done in this case is, since they will not be able to understand the nitty-gritty of the law involved, so I've asked them to have counsels for themselves. They both have legal aid counsels, they are represented by counsels, and the counsels whom they are representing, the parties, I've spoken to them, I've spoken to the party as well. But now the predicament which I am facing is, I will be deciding with regard to these two children. The wife and the husband, they cannot stand each other. That I have seen them in the court also. They can't stand each other. They want to divorce, but eventually now I'll have to decide with regard to the custody of the child, for which the assertion of the father is that the mother is not capable enough to look after the child, the children, because then she is a alcoholic and she leaves the child here and there. He has to go and pick them up from here and there. And the assertion which the mother is putting upon the father is that he is a police personnel. He does not have timings to come home. He will not be able to look after them because then he only has old age parents with him and nobody is there to look after the children. This is
The children.
Yes.
What is his family backup like?
I am not quite sure, because then the mother's family, I think they are not supportive enough, because I called the brother also of the mother, and the brother says this dispute of them has been going on for quite some time now and they are fed up with these. They will not be able to look after both the children. That is the assertion of the brother of that mother. And the husband's family, I have not called them. But the husband says he has old age parents, but then they can look after the children. That is his thing.
What I would do probably, left to me, to take a divorce, because you have proof that she's an alcoholic. And has she committed to trying to change herself?
She went to a rehab, but the proof has not been produced before me. I do not know what they will eventually do when they find their documents and other things. But as of now, the only evidence produced before me is that she's gone to a rehabilitation center.
Okay,
He has asserted so many things that she goes with him or her or whatever, but then those proofs he's not produced before the court. The only thing is she was an alcoholic, she's gone to a rehabilitation center, she's taking treatment, and then one day he has also filed an FIR against the lady. Because then...
Saying what?
Because then he met her with some boy in the boy's house and in the guy's house, and the children were left alone when she went to meet that person, and she had a fight with that person, and she had all the bruises all over her faces, and he has submitted a photograph to that effect. So he says, in no way is she competent enough to be a mother to those two 9-year and 5-year-old child.
Thing is, you have met the mother.
Yes.
What did she seem?
She is a little, I will say, I will not say a mother will be incompetent in any manner, because she is a mother, but then...
Yes, but...
yes, that is evident when I see her, because then she forgets her date, she does not come in the date, then she skips 2 days, again I have to send her notice because I know her status. Then she comes back, and when I ask her why didn't you come in the earlier date, that was before I fixed the lawyers for them, no? Because that was one of the...
At least they can be represented.
Yes. So when I asked her, she says she just forgot the date. And one day she came up with all the bruises. That was when her husband filed a FIR against her, and she was saying that she fell down. So those things are evident on the court.
And the FIR says she got into a fight.
Yeah, but no, I think that was the FIR which the husband lodged. No, she was with this man and she had a fight with this man. And she left.
And who's that man?
I do not know. That is just an assertion. and she says it is not the truth. But the husband has filed a photograph and the FIR is there. And the same that coincidentally the date of the court was fixed on the same dates, and I could see bruises on her. So I don't know.
It is unfortunate. Possibly considering you can, what I would do is send the girl to boarding school. The older child, a 9-year-old. But a 5-year-old is tough.
Exactly. The 5-year-old is a girl child.
The boy can be sent to boarding school, because I think that would be in the best interest of the child. But the younger one, if the grandparents or someone can look after them with counselors visiting every now and then, like surprise visits which is provided for in the Family Courts Act and rules, maybe at least you'll be able to monitor the child, but you'll have to keep tabs on the child. And then again, you'll have to think whether you want to separate the siblings. Because one goes off to, I'm sure in all this bitterness and fight, that siblings have become closer to each other. They probably look to each other for support. But 4 years is a big difference. You won't be able to, it'll be difficult to send them to the same boarding school or together.
Otherwise, she can give the custody of both the children to the father for the best interest of the...
Yes, she can. But then it should be monitored. And right.
If any problem, then she can modify the order.
Yes. Give the custody to the father, let the mother visit. Definitely allow her visitation. Follow up with the visitation, what happens. Like whether she attends them or she forgets, or she goes there drunk, or she realizes that now her children might be taken away from her, so she might just pull up her socks and improve. I think temporarily you can give an interim custody and try it out. I am actually no one to tell you this.
But I was also faced with this situation.
This dilemma, yes. Sometimes it helps to discuss.
These are things you cannot go by book to book and go to...
You can't. That's exactly when I was writing this.
Holiday, they can visit the place of mother.
Initially, I think let the mother only visit. Some first month or so, definitely in the presence of the counselor, so that she can report back on how the interaction is with the children. Because the father will always tell you negative things, the mother will tell you positive things. So you need a witness, independent witness over there.
Thank you.
You're welcome. Coming back. So, as we have now seen, the courts should always favor children to have contact with both parents, unless one or the other parent has history of abuse or other behaviors which can endanger a child, which is what we just discussed. If there is any potential of any harm coming to the child or his or her studies or routine, then certainly the mother should not be given custody. There are some other factors, that is the age of the child, the stage of development, the emotional, social and educational needs. Like a 5-year-old, as we just discussed, is barely going to school, and a 9-year-old has more routine, more workload. The health, welfare and safety. The story we just heard about the children being left here and there where the mother has disappeared, certainly does not inure to the safety or well-being of the child. Next, the quality of the parent-child relationships. That's also very important to consider. Watch how the children interact with the parents. Some parents can determine a custody and visitation schedule on their own. Most parents, however, need the help of courts. Even then they fail. Recently I was involved in a case where the father was allowed access in a mall for 2 hours on Sundays. The mother used to turn up without the child. And then the judge got angry and said, that's contempt. Then she used to come to the mall late and then say it's hot, she's not well, insist on hanging around. So it's difficult, but you have to be pragmatic. But unfortunately, I don't know if I should be saying this, but in district courts, judges are usually in favor of the woman. The ladies are given preference, which is unfortunate because a lot of them don't realize that the father has equal rights and opportunity, and not always is the case that the woman is right. Not every mother is a Bharat Mata. My children will shout at me because maybe I'm saying the wrong thing, but not every mother is cut out to be a mother. I know that from experience, and sometimes it's circumstances, sometimes it's career, sometimes it's depression. There are many reasons. Anyway, I digress. Few reconciliation tips from me. Parents should leave their emotions outside the door. You need to tell them, take your feelings, go. Leave them there, then come back and focus on the best interest of the child. When they want to air their dirty laundry and tell you things about each other, you have to stop them. Do not allow the parties to engage in back and forth banter. You did, I said, you said, that day you did, 5 years ago you said. Let them focus on the child or the children. If there are valid concerns about the other partner's ability or to care or to manage a schedule, the father's too busy or the mother has other issues, do listen to both of them and make reasonable suggestions. It's a repetition of what we discussed. Be firm but be reasonable. One party has to back down sometimes. There's a reason they can't live together anymore. Focus on the child. Under no circumstances should the court allow its own family or morals or ideas of ideal parenting to guide them. There is no ideal parent. There is no perfect parent. Each person does the best they can. There is no best mother awards. Each mother, each father does what they think is best for their child. Listen to the parties and children. If the children are old enough, call them. Listen to them separately. Watch them how they interact with their parent. And do not, I think this is very important, do not consult with in-laws and relatives. They always will take a side, they will just distort the picture. You won't believe the amount of times I've got a call from someone saying, I want to speak about a divorce, my son needs a divorce. Initially I used to say, okay, tell me. That's when I was very junior. Then I learned very quickly that the children don't want a divorce. It's the father or mother who's unhappy with the daughter-in-law or the son-in-law and they wish they were divorced. So now after that, as soon as I learned that, now I always tell them, please send them to me, you don't have to come. And often they still accompany and you have to send them out of the room and just talk to the parties. So that is very important. Except, you have to accept that no parenting plan is going to make everyone happy, never. The goal is to reach an agreement that is 80% agreeable to all parties. No one's going to be happy. Everyone will want more. Custody law in India is of many, as you know, Hindu Marriage Act, Hindu Minorities and Guardianship Act. Section 6 of the Minorities and Guardianship Act states that the natural guardian is the father and after him the mother. In this case of Geeta Hariharan versus Reserve Bank of India, I'm sure you all have heard of it. It's reported in 1992, Volume 2, SCC 228. The validity of Section 6A, where it says first the father, then the mother, was challenged as being violative of Articles 14 and 15 of the Constitution. The petitioner, Geeta Hariharan, claimed she should be an equal guardian to her child and should not come after the father. While earlier in some cases, I'll come to that later, there have been instances where the mother was appointed guardian. This was a landmark judgment because here the Supreme Court held that the word after shall have to be given a meaning which will subserve the need of the situation, that is, the welfare of the minor. Having due regard to the fact that the law courts endeavour to retain the legislation rather than declaring it to be void, it is expedient to record that the word after does not necessarily mean after the death of the father. On the contrary, it depicts an intent to ascribe the meaning thereto as in the absence of the father, be it temporary or otherwise, or total lack of interest of the father towards the child, or even the inability of the father by reason of ailment or career or anything. So it is not that the father is the natural guardian. Father does not come first. This is the first judgment that said this, and it was upheld by a three-judge bench. In many of the judicial decisions, welfare, best interest of the child is primary and paramount. It has also been held that in cases of custody of a minor, paramount consideration is the welfare of the child, not the rights of the parents. Thus, it is not the negative test that the father is not unfit or disqualified to have custody, but the positive test that the custody would be favorable or more amenable for the welfare of the child. That is the issue that is to be considered. On that basis, the court should exercise power to grant or refuse custody of a minor in favor of a father, mother, or any other guardian. There are cases where a grandparent could apply for guardianship, or under Muslim law, father is considered as the natural law, of course. Under Shia law, a mother is entitled to custody of the minor son till the child is 2 years of age, and custody of the minor daughter till she is 7 years of age. Under Sunni law, which is more common in India, mother is entitled to custody of the son till he is 7 years, and of the daughter till she attains the age of puberty. Here too, courts have time and again emphasized on the principle of best interest of child. Children cannot be treated as chattel or property. The welfare has to be considered more on humanitarian grounds. In the decision of Akhtar Hussain versus Syed Siraj Ahmed, reported in 2010, Volume 2, SCC 654. sorry. It's okay. I think I've got it under control. I'm sorry. In this case, the children were residing with the maternal grandparents after the mother's death, and the father initiated custody proceedings. It was held by the Supreme Court that although the father is the natural guardian according to Muslim law, the court could not overlook the preference of the minor children and the interest of the children. Ultimately, the court found it was in the interest of the children that the custody should not be disturbed and remain with grandparents, and the father was allowed to visit. Under Christian law, sections 41 to 43 of the Divorce Act addresses the issue of custody. Sections 41 to 43, as you must be knowing, here again minus welfare of the child. There's a case of Jacob versus Jacob, one of the earlier decisions in 1973, volume 1, SCC 840. That's where they said, actually Supreme Court said that children are not property, they are not toys or playthings for their parents, that they on their whim and fancy they take the children or leave the children. Under the Parsi law, do you have many Parsi cases in Sikkim? Not at all. But there's a judgment I will consider. In the case of Thriti Hoshi Dolikuka versus H.S. Dolikuka, that was reported in 1982 Supreme Court cases 544. There too, it was held that the question of custody of the child must necessarily be considered from the viewpoint of the welfare of the child. In this case, Supreme Court found that there is so much bitterness between the parties, the best interest of the child would be served by keeping her in a boarding school, away from the unhealthy atmosphere which she was at home. This judgment, if you get round to reading it, you will find this very interesting. This child was a very good student. She was doing very well in school. The father wanted to take her out of the boarding school, and the courts didn't allow it. So, each case is different. You cannot have a straitjacket formula. Courts have consistently ruled in favor of the presumed welfare of the child over personal law. Personal law comes next. This demonstrates a desire to implement legal provisions with a consistent welfare of the child interest. Most faiths have not opposed this. Most religious groups are okay with protecting the children. So that has also created an arena where the courts have been able to cater to the welfare and interest of the child, which is a good thing. Guardianship also, like custody, is like custody, but it's actually a bundle of rights. It's not just custody, it is a little more than custody. Custody is a narrower concept. Surprisingly, interestingly, custody has not been defined anywhere in the laws. You won't find the definition of custody. And Guardians and Wards Act is secular, irrespective of your religion, anyone can apply. And for Hindus, Buddhists, Jains, Sikhs, there is a Hindu Minority and Guardianship Act. The great thing about custody and guardianship orders is you can have interim orders, you can have final orders, you can change it, you can recall orders, you can depending on the facts and circumstances of cases, these courts are authorized to revoke, suspend, or vary these orders. Things like inflation, higher education, the child grows up, wants to go to college, expenses, even extracurricular activities, tuitions, all this can be incorporated later and again and again. It can be varied. This is not a judgment that is given and that is the law. Even the doctrine of estoppel, I'm sure, is not applicable. Just because I agreed today that yes, you have the child for 2 hours, but then the child comes home with bruises, I can say I don't agree anymore. So, even when custody or guardianship matters, even when orders are based on consent, can be varied by the court, if the welfare of the child demands such variation. Factors to be kept in mind while determining guardianship will apply with equal force to the question of interim custody. Temporary custody of and protection of the property of the minor, those are under the Guardianships Act, which can be done at the interim stage, later stage, and thereafter also varied. Apart from the statutory provisions that are there in the Guardians and Wards Act, examination by the court of the child is important and desirable. It helps the court in performing its duty, in exercising its discretionary jurisdiction, and also deciding the delicacy of the issue of a tender age child. You're speaking of young children, you're not. So, you have to be sympathetic to their situation. We move to maintenance. This is the other primary issue, the most important issue. After all, everything boils down to money and property. Maintenance under classical law refers to a husband's obligation to financially support the wife during marriage and also on divorce or separation. Provisions come out of the Civil Procedure Code and other personal laws. In recent years, typically it used to be for the husband to provide the wife, but in recent years courts have also started denying maintenance to women who have the capacity to earn independently and are not financially dependent on their husbands. Challenges have also come to courts with men requesting maintenance from wife, where the wife is the primary income earner. So we are trying to equalize the balance. The right of maintenance is, of course, recognized as a statutory right that serves a social purpose to prevent women from becoming destitute or impoverished following a breakdown of marriage. It is recognized as a means to secure all women an adequate means of livelihood under Article 39 of the Constitution, and when read with 15(3), it may be awarded to women as a special provision. In a case in Calcutta, reported in 1981, AIR 1981, Calcutta 123, one Mr. Poonananda Banerjee sued the court in a proceeding for divorce filed by his wife, challenged the constitutional validity of Section 36 of the Special Marriage Act. What's the difference between the special maintenance under Special Marriage Act and the Hindu Marriage Act? Hindu Marriage Act allows the husband to claim maintenance. Special Marriage Act does not. Under Special Marriage Act, the husband has no right to claim maintenance. So the constitutional validity was challenged in Calcutta High Court because it did not provide the husband with the option of claiming maintenance. A division bench of the Calcutta High Court upheld the constitutional validity of Section 36 in view of Article 15(3) of the Constitution, which states that nothing in this article shall prevent the state from making any special provision for women and children. Such interpretations by court demonstrate the level of importance given to maintenance as a right for women. However, and its intention to serve women so that husband cannot trick the wife. Some of the different laws on maintenance, section 125 of the CRGC, which is primarily used. There was a case in Chanmunia versus Virendra Kumar, where Supreme Court held that women in live-in relationships can also claim maintenance. You don't have to be married. I'm sure you're familiar with that one. Where a man lived with a woman, even though they may not have gone a legal marriage, is still liable to maintain his wife if he deserts her, his partner. The object is that a woman should not be led to vagrancy and destitution. Unable to maintain herself does not mean that the wife should be destitute before she comes to court for under 125. In Chaturbhuj versus Sitabai, reported in AIR 2008 SC 530, it was observed that the wife should be in a position to maintain a standard of living which is neither luxurious nor penurious, but consistent with the status of the family. Non-payment of maintenance, what happens? You punish a person for non-payment. Civil imprisonment also. But the liability under 125 does not end upon civil imprisonment. It ends only on the payment of the arrears. The punishment is not a mode of satisfaction. It is only on enforcement of the liability that the order can be satisfied. The execution of the order is upon satisfaction of the payment, not mere imprisonment. Hindu Marriage Act brought even the husband or the wife during any proceedings can apply for maintenance. Under section 24, it can be granted only when the proceedings are pending. However, not maintainable when the marriage is void. When a marriage is void, what are the conditions? You tell me. Bigamous marriages, when there's more than one husband or wife, prohibited relationships, and sapinda relationships. Those are the relationships which are void. However, section 24 is not maintainable in a void marriage. This is a problem for women who are unable to prove their marriage status or whose marriages are declared void. Leaves them financially vulnerable. So this is an issue that needs to be thought out. Because an innocent party might get into a void marriage. I might get married to X without knowing that X is married to Y. when I find out my marriage is void, but I'm not entitled to anything. This is something that requires thought. And it's the courts that can show the way. Section 24, maintenance, when it is given, includes considerations such as the applicant's own income, income of the respondent. Maintenance cannot be punitive. It should not expose the non-applicant to unjust contempt or coercive proceedings. And then maintenance should not be so low that it becomes a joke or makes the order meaningless. Income affidavits or affidavits of assets are very important. These are very efficient tools. There's a very recent judgment which was delivered on 4th November 2020, reported in AIR 21 SC 569, Rajneesh versus Neha. Here the Supreme Court has given a format for the criteria for broadly determining the quantum of maintenance payable to an applicant. There's a part B of this act. I would invite you to see, which actually sets out very broadly what should be contained in the affidavit of assets. And that's very interesting. It's a very interesting judgment because not just does it consider money, it's a nice template. You can just hand it to the parties and say, just fill it up.
So the problem here, what we face is 125, we have maximum cases. If you look at family courts, 125, we have a huge number of cases. But then if you look at the income of the boy, either he's a labor or a driver. Wait, no, so they don't have that socio-economic condition is not good. So we are faced with this challenge, no?
That is there. No, that is always a problem. Even like these are, I suppose, applicable more for the
Yes.
bigger divorce seekers. That becomes the problem. That's when you have to like go on that basis of 1/3 of income, which is what the courts usually grant the wife.
If we ask to pay 3,000 rupees, then definitely after 2 months they will file execution petition. Thereafter very difficult to execute or one order.
I know, I
They
understand.
don't have the source of income, the problem is.
Or they lose their job. If they're children, that's another issue. These are practical things which I don't think the legislature considered when they made these laws. I might be beaten up when I leave this place.
No, but the ground reality, what we face.
Ground reality is that poor people are really poor in our country, and it would not be fair to say that the law is not made for the poor, but in some circumstances we have to say that yes, firstly accessing justice is difficult for them. That's where family courts is a great idea because they don't need to go through big and expensive lawyers. And lawyers, to be fair, usually look after their interests before their client's interest. That's another discussion. We should have another day because but that's a very pertinent discussion.
What I've also noticed is the drafting. Most of the lawyers, they have a template for family court cases. So even if it's not applicable, they will write
All those things, those set format.
Yes. And sometimes even if the parties are kind of agreed on divorce, the moment they see the petition, then the other party gets very engaged. I've never done this, so why is this allegation here? Then that's when the actual
Fight begins, and then the lawyers step in.
arises actually.
I think maybe you all should have a format where you say that no legalese, just state what you want to say in clear words. If we need legal assistance, we'll ask for it. Maybe something like that could be done in the family courts.
That is what we are doing. We don't allow counsels.
No, you don't allow counsels, but these people are frightened. They've gone to a lawyer 3 times before they've come to you. And the lawyers will give their 2 bits. You must say this, you must say
The
that.
problem again we'll face is they'll not be able to draft themselves.
Let them write it in their own language, like a will. The best wills are handwritten and in plain layman terms. Tell them that is what we want. That is an idea.
That's an idea.
Because then you also understand, they also understand. Let them read it out if you're not familiar with the script.
But again, with e-filing and all, the handwritten petitions get slightly.
Oh yes,
Another possibility.
you just have to
You
scan
just need a
it.
lawyer again to do the filing again in the court. You know?
I think these formats and filing systems, petition, this, that should be done away with, at least for some sections of society.
That's what we also feel.
Endeavor to, you can maybe suggest this or consult the Chief Justice on this.
When it's too technical that the common people are not able
Yes,
to
for the common people, but what would be the cutoff for common people? Anyone holding a non-salaried job, non-permanent job maybe.
The other petition which usually comes to me is mostly the divorce is filed either on cruelty or desertion. Now the parties come to me, I ask them, this is what you've written and what is your status now? They say they have been living separately for 3 years, 4 years. And then I tell them, why don't you come under mutual divorce? And they say they were not aware.
This is the problem. The lawyers give all the lawyers. What I'll tell you honestly, I'm one of the lawyers who doesn't like acrimonious.
Before coming to me.
Yes, I'm sure you all were. We all like acrimonious litigation. More fees, simple. But I actually discourage them. I always try to work out a mutual, because acrimonious divorces are waste of time. They take forever, and it's you said, I said, and the evidence it gets very messy. So I think this is something you need to address. At least anyone with a non-permanent job or without a job which gives you allowances or DNS allowance or without security, you should have a different format for them. Maybe you can think about
All
this.
made our own jugars for all these.
Yes, that you have to. I guess that is required. I'll just, this segment I'll end with one thing. I'll talk about the Shah Banu case. I'm sure you have Muslims in this state a lot. The Shah Banu case, 85 volume 2 SCC. I'm sure you're aware of it. It said that the Section 125 of the CRPC was applicable to everyone without restricting religion. This, as you all are aware, created a huge reaction, caused the government to pass the Muslim Women Protection of Rights on Divorce Act, which diluted the judgment of the Supreme Court and restricted the Muslim divorcees to alimony only for 90 days. In later judgments like Daniel Latifi, Supreme Court interpreted the Act in a manner reassuring the validity of the case and consequently upheld the Shah Banu judgment. Some Muslims supported the Supreme Court order. Muslim Personal Board questioned the authority of the court to interpret personal laws. Court concluded that the Act does not preclude maintenance for Muslim women, and Muslim men must pay spousal support until such time as the divorced wife remarries. In fact, the court held that if the Act gave Muslim divorcees unequal rights to spousal support, it would be unconstitutional. I am mentioning this case, this infamous case, as I say, because we also need to change a lot of things in personal laws. I am not against religion. I believe everyone has a right to their own faith, their personal laws. But there are also places where we need equality. Equal provisions for all persons of all gender, all orientations. So that won't really be possible if we keep giving narrow meanings to personal laws. So when awarding maintenance or custody, this is something we have to keep in mind, that there are roads and ways to bypass the system and maybe come to a better ruling, better settlement. I'll pause here for now. Let's all have tea. Please don't let your teas get cold. Decided to do a little interactive session. It's a quiz. Questions and answers. You want to divide yourself in teams, you can. I can just answer. Fastest finger first.
I think we'll do it as a group.
Yes, certainly. Okay? I thought we can have a little fun also. Okay, choose the correct option. All of them are that. Desertion within the purview of a Hindu Marriage Act is total repudiation of the obligations of marriage, partial repudiation of the obligations of marriage, a suspension of obligations of marriage, or equivalent to judicial separation.
Total.
Yes, correct. Total. Next, I assume this will be very easy for all of you. Which one of the following is not a ground for divorce? Desertion, mental cruelty, adultery, irretrievable breakdown of marriage. That is too easy. Huh? Yes.
Because now it is.
No, it's a ground for divorce only in a divorce by mutual settlement. Otherwise not. You can't go to court and say, my marriage has broken down, divorce me. Get a pen. 3. Consent theory of divorce was introduced in the Hindu Marriage Act in the year 1979, 1976, 1964, 1956. 76. Before that it wasn't there. It's an act of 54, but the mutual concept came much later. The Divorce Act has had it. No, it doesn't have it. Sorry. Okay. Sodomy is a ground of divorce under the Hindu Marriage Act, Christian Marriage Act, Dissolution of Muslim Marriage Act, or Divorce Act. Yes. Next. The bar to entertain a petition for divorce under the Hindu Marriage Act operates for a period of 3 years from date of marriage, 2 years, 1 year, or 6 months.
1 year.
Dastane versus Dastane is a case reported in AIR 75 SC 1534 on adoption, divorce, marriage, maintenance. Which one? Dastane versus Dastane. Divorce. You know why this one is unique? This is the first case where mental cruelty was considered a ground for divorce. Earlier it was only physical cruelty. In this case, wife who suffered would be entitled to be maintained by the husband. This is the case that said that. AIR 75 SC 1534. Next, A bigamous marriage under the Hindu Marriage Act, I actually told you this earlier, is adulterous, void, voidable or irregular. A child born of a void or voidable marriage under Hindu law is legitimate, illegitimate. X marries Y, his elder brother's widow. Marriage is valid, void, voidable. None of them. Void. It comes, I know it was a tradition that the husband died, the wife was married by whoever, or the wife died, the husband married the sister. But those are void marriages. A Hindu wife is not entitled to separate residence and maintenance if she has become unchaste, ceases to be a Hindu by conversion, is living separately on her own volition, or all of these. Hindu Marriage Act, decrees of prohibited relationship is defined under Section 3B, 3C, 3E, 3G. Each can choose one, A, B, C, D. It's G, 3G. That is prohibited relationship, I'm sure you all know, lineal descendant of each other. Registration of marriage has been made compulsory by the Hindu Marriage Act 1955 under section 10, 9, 8, 12. On 30th April this year, 4 days ago, the Supreme Court, I don't know if you followed it, emphasized that for a Hindu marriage to be valid, it must be performed with appropriate rites and ceremonies, such as Saptapadi. Mere registration will neither confirm the marital status of the parties nor be recognized as a valid Hindu marriage. This I found a little contradictory to the next day, 1st May, Supreme Court has passed another judgment emphasizing that a Hindu marriage is a sacred institution and should not be trivialized as a mere social event. All this dancing, partying, all this hi-fi weddings that we see all over TV, it's become a status symbol and a power show. So that judgment has also just come out. Do look at them. I plan to, means it's not accessible so much yet. Okay, next question anyway. A child born out of the void and voidable marriage under Hindu law is, I think I asked this already. Okay, which of the following is not a ground for divorce under Hindu Marriage Act? Apostasy, insanity, venereal disease, epilepsy. Is leprosy a ground?
Leprosy of chronic leprosy.
Yes, not the mild one which can be treated. Okay, a Hindu male aged 28 years, adopts a female child of 13 years. Adoption is valid or invalid? Voidable or void?
Your gap bigger than 22 years. There has to be a male adopt a female child.
At least 21 years. So it is void. Section 9 of the Hindu Marriage Act was held to be intra vires of the Constitution. Firstly, what is Section 9? Section 9 is when the husband or wife has separated or left, then they may apply to the district court for restitution of conjugal rights. Okay. So it was held to be intra vires of the Constitution by the Supreme Court in the case of Saroj Rani versus Sudarshan Kumar, or Seema versus Ashwini Kumar, Shanta Devi versus Kanchan Prabha Devi, Shanta Dev, sorry, Mahendra versus Sushira Bai. Any idea which one? Okay, anyway, it's Saroj Rani versus Sudarshan Kumar in AIR, reported in AIR 84 SC 1562. This is considered landmark case. It challenged the constitutional validity of restitution of conjugal rights. It is considered a matrimonial remedy. It's supposed to be a positive remedy. The division bench of the Supreme Court held that it is validity under the Constitution. But, this is my input, the very concept of restitution ignores the fact that if the parties have reached a stage of the relationship where they are unwilling to give each other the consideration required, forcing them to live together will only make it worse. And think about this. Is that not a breeding ground for marital rape? Can you force someone to live with someone? Anyway, moving on. Concealment by the respondent of pre-marriage pregnancy by someone other than the petitioner can make a marriage void, voidable, illegal, valid. Prescribed period of limitation for preferring an appeal under Section 28 of the Hindu Marriage Act is 30 days, 45 days, 60 days, 90 days. 90. In giving a child in adoption by a Hindu father, the requirement of consent of mother can be dispensed with if she has been declared to be of unsound mind, she has wholly and financially renounced the world, she has ceased to be a Hindu, all of the above. Hindu wife is entitled to claim maintenance after the death of her husband from her father-in-law. Under which provision? Section 10 of the Hindu Succession Act, Section 24 of the Hindu Marriage Act, Section 25 of the Hindu Marriage Act, or Section 19 of the Hindu Adoption and Maintenance Act. Hindu Adoption and Maintenance Act, Section 19. Hindu Minority and Guardianship Act 1956 does not apply to scheduled tribes unless notified by the central government, Jains and Renokans of the Union Territory of Pondicherry. Which one? Scheduled and also Renokans. Who are Renokans? Renokans are natives of the former French possessions in India, in Pondicherry, who have given up their personal laws. So it doesn't apply to them. The principles laid down in the case of Jijabhai Gazre versus Pathan Khan is related to dissolution of marriage, succession, adoption, minority and guardianship. Minority and guardianship, this is the first case where even in the presence of a father, mother was appointed guardian. As I said in Gita Hariharan, this is earlier than that, but this did not discuss or clarify that after father doesn't mean death of the father. Essential requirements of a Muslim marriage are Qabul, Ijab, both Qabul and Ijab, none of these. Both of them. Don't forget, in Muslim marriage is a contract. Qabul is acceptance, Ijab is proposal. So, just as a contract cannot exist without a proposal and a agreement, same thing. During the term of Muta marriage, wife has no right to divorce, husband has no right to divorce, husband and wife both have a right to divorce, neither of the parties have a right to divorce. Muta marriage. What is a Muta marriage? It's a marriage for a fixed period, only for sexual pleasure. Muslim law in the Shia sect recognizes this concept. There is no right of divorce, but the husband can put an end to the contract by making a gift of the dowry that was given even before the term ends. Like suppose I have a Muta marriage for 3 months. After 2 months, I'm tired of the woman. I can pay her and it's really rude. In a Muslim marriage where the bride's age is below puberty, but the guardian gave consent, marriage is unlawful, voidable, void or irregular. Voidable. If she grows up and says, no, I want to remain in this marriage. A marriage between persons with a consanguinity relationship under Muslim law is Sahih, Fasid, Batil, none of them. Consanguine relationship, not Sahih. Sahih is valid, Fasid is irregular, Batil is void. This is Batil. You don't have. Anyway, it's interesting to know. Under Muslim law, the marriage, whether consummated or not, iddat has to be observed in the case of divorce by husband, death of husband, both divorce of husband and death of husband, none of them. Both. Even if he divorces you or if he dies. Iddat, is a period of time that a woman must observe when she cannot marry again after her death, her husband's death. Usually this is it's about 90 days. It's followed by the lunar calendar. In Muslim law, divorce by li'an is a right available to the wife only, husband only, both husband and wife, neither husband and wife. Sorry, I know these are getting confused. Okay. Li'an is what? Li'an is when a husband accuses a wife of being unchaste. So this is a ground available only to the woman, to the wife. That accusation itself is a ground. Under Muslim law, prompt dower is payable at the time of marriage, when demanded, at the death of the husband, at the divorce of the husband.
At the time of marriage.
When demanded. That is prompt dower. That is deferred dower is given when he dies, and otherwise regular the dower is given at the time of marriage. That's the beginning. They promise, but they don't always pay. So whenever the wife demands, he has to give. How many witnesses are compulsory required in a Shia Muslim marriage? 1 male, 2 females, 2 males, no witness, 2 females. No idea. I know, I'm sorry. No witness. In Sunni law school, in Shias you don't need a witness. Sunni school is more particular, explicitly needs two witnesses to be present. Both should be male, both should be Muslims. Enforcement of the order of maintenance is provided under Section 125 of CRPC, Section 126, 127 or 128. 128. Enforcement. Who are eligible to receive maintenance under Section 125(1)(b) of CRPC? Only legitimate children, only illegitimate children, both legitimate and illegitimate, or only married daughters? Right. What is the Prohibition of Child Marriage Act? A law that aims to prevent dowry, a law to prevent dowry and marriage of underage children, a law that aims to prevent and prohibit child marriages, or a law for children to be wed by adult males. Right. What is the minimum legal age for marriage for girls in India under this Act? 18, 16, 21. For boys?
21.
At least we all know this. What are the penalties for those who participate or promote child marriage? Imprisonment, imprisonment for up to 2 years and a fine or a fine, or rigorous imprisonment for 7 years. 2 years and a fine, but I think it should be a rigorous imprisonment based on the age of the child, inversely proportional to the age of the child. Can a child marriage be declared void against under this Act? Yes, no, maybe, or voidable at the request of either party.
Voidable at the request of the party.
Which form of marriage is inherently free of conflict between husband and wife? Monogamy, polygyny, polyandry, polygamy, none of the other. Which form of marriage is inherently free of conflict between husband, wife and children? Monogamy, polygyny. Yes, monogamy. What are the other ones? Polygyny is what?
More than one partner.
One man, many wives. Polyandry. One wife, more than one husband at the same time. Polygamy. More than one wife at many times. This is why family law is so confusing. There's so much to consider and so many people just do what they want. Which section of the Family Courts Act gives jurisdiction to the court? 7, 20, 29, all of them. 7. Special Marriage Act, okay, well, what's the applicability of the year? Okay, never mind. What is one unique feature of the Special Marriage Act? Unique feature.
People from all communities, all religion can get married.
Anyone.
Anyone.
There are no personal laws. Anybody. Nowadays a lot of people are getting married, even Hindus are getting married under the Special Marriage Act instead of the Hindu Marriage Act. And I asked someone and they said, so that the personal laws are not touched. To consider condonation under to constitute condonation under Divorce Act, which of the following is not required? Full knowledge of all circumstances, forgiveness, restoration, or written apology. What is not required? Written apology, right. Which of the following is a ground for nullity of marriage under the Divorce Act? Impotency at time of marriage, adultery, husband being found guilty of rape, or cruelty. Nullity of a marriage, not divorce, not a ground of divorce, nullity.
Divorce Act is not enforced here.
Not enforced here.
So that is why
No idea. Okay, it's anyway. Nullity it becomes if there is impotency at the time of marriage. Unfortunately, the Divorce Act doesn't have the ground of cruelty. So, unfortunately, if someone wants to sue for divorce, they have to either charge them with adultery or what else? Adultery and cruelty, not cruelty. So you get a whole lot of these petitions, you'll see where they will name a correspondent, and it's very unfortunate. They are not allowed mutual consent. Yeah, they are allowed cruelty and adultery. Which section? What are the hours between which a Christian marriage can be solemnized? 6 a.m. to 7 p.m., 4 a.m. to 8 p.m., 5 a.m. to 9 p.m., 9 a.m. to 9 p.m. Actually 6 a.m. to 7 p.m. Anyway, I think I'll skip the Christian Marriage Act questions.
that's also not enforced here.
Christian Marriage Act, Parsi Marriage Act also not. Then I'm done with my questions for now. Any questions, anyone?
I just wanted to ask the recent judgment passed by the Supreme Court that the what do you call it? The ceremony has to be performed. So what about those cases where parties just choose to go for a court marriage without performing the ceremony?
That's exactly it. Since registration is compulsory, this is exactly what we were discussing last night, that it just confuses everything. First you say registration is compulsory, okay. So I don't want to do the rites, but I think this can be distinguished on this issue that it won't be recognized as a Hindu marriage.
But a marriage.
But it's a marriage, a registered marriage. So there's a hole over here.
So it's a new fad amongst the coming generation.
Yes.
That they don't want to do a ceremony.
Yes,
They want to
completely.
And they directly want to do a court marriage. They go to the district collector.
So they should go under Special Marriage Act, I guess.
That's the only thing. Because usually they get themselves married under the Hindu marriage act.
Now this is, I think, a little on religious tones. Because the way the language is, do you have the judgment? Mere registration will neither confirm the marital status of the parties or be recognized as a Hindu marriage. It's been specified it won't be recognized as a Hindu marriage. But then the registration, I'm sure, says this is a marriage under the Hindu Marriage Act.
Yes.
Registration certificate. So this does leave room for debate. I'm sure some clever lawyer will come up with something.
This new generation of young
Yes, I understand completely, because that's how I also wanted to get married, but I wasn't allowed. But my children definitely don't want to do all the fera and all that. Anyway.
If male is a Hindu and female is a tribal, they got married as per Hindu Marriage Act, then one can file divorce.
If it's a Hindu tribal, why not? It's applicable to tribals also, no? I don't see any bar. Means I wouldn't consider it a bar. It's a Hindu tribal. They don't have special status or anything like the scheduled castes. I know scheduled castes, scheduled tribes, they say. But I think it would be applied. I may be wrong.
Out here, ma'am, we are actually left with quite a dilemma, so to speak. Like, we have a lot of tribals, right? And most of them got married under the Hindu Marriage Act. And now, most of them want to file, not most, but
Some of them
want to file for divorce. And now, since the tribal thing is excluded, scheduled tribe. They're excluded. I mean, they're not included under the thing. So now they just don't know how to go about it. So there are actually a good number of people who are waiting to be divorced, who want to get divorced, but they're not being able to get a decree from the court for this reason. And even the courts, we are also left with no option but to just tell them like,
Wait.
just wait.
We don't have a remedy.
We don't have a remedy only. Like we are actually coaxing some of the lawyers to approach the Honorable High Court to see if something can be done, you know, with regard to just the status of Sikkim.
Listing of tribals is also a state list. Comes under the state list. It's a concurrent thing. Center has a list and backward classes and all. We also have a list. I mean, every state has a list, separate list. So can't you apply to have these tribes in the state list and then give them a divorce?
That's what we are hoping. So that's why we are coaxing some of the lawyers like, please approach the Honorable High Court and see if some directions can be followed.
You cannot. Very technical problem.
And there are many, good number of people.
So they've gone to desperate measures. Like there was this time.
But then if you have them moved from the list or moved into the list, their rights will be...
Again, because we have special laws for them, protecting
Yes.
properties and land.
So the special laws cannot be amended to include these family disputes. Where do they go if there's domestic violence and physical abuse?
They come under the Domestic Violence Act 2005, no doubt.
Okay, so why don't you ask that this act be amended? Approach the Sikkim Legislative Assembly. That's another option. Just have the act to include.
That only High Court can pass it.
So that's why we're telling the parties that just approach the Honorable High Court, maybe there can be some intervention.
Maybe you all can talk to the Chief Justice and get a suo motu public interest litigation. That's also possible. Because these are problems we face and these are ground realities. People sitting in the center and in the big offices don't think of this. This is a problem that happens when you are there on the ground.
We have problems executing our own orders. We have problems executing our own orders.
Of course. As she said, the 3,000 rupees also. Okay, come to my last segment. Any more questions? Nothing. Okay, role of judges in amicable settlement of family court cases. This is the key subject that we are talking about today. The very purpose of the Family Courts Act is to provide for the establishment of family courts, I'm quoting here, with a view to promote conciliation and secure speedy and amicable settlement of disputes relating to family, marriage and family affairs and for matters connected therewith. So far, we've discussed how judges need to be sensitive towards the problems of the couple and the family and everyone. Merely being sympathetic or sensitive is not enough. We all can be sympathetic, it's nice. But it's never enough. Because one or the other party will try to degrade the other party and show that how much smarter he or she is. Judges today, luckily, have more discretion in family cases than any other private field of law. You have a lot more discretion, a lot more space. Because as we said, marital problems are not mathematical equations. There is no straitjacket formula when it comes to deciding a family case. Each case has to be evaluated in the light of the particular facts and circumstances of that case and that case only. Earlier, divorce law relied on what? Judicial wisdom to get fair results. You went to a king, he would tell you, okay, this way, that way, you go there, stuff like that. It was supposed to be divine justice or whatever in the ancient days. Anyway. But nowadays, legislatures have typically given judges and family courts almost unlimited discretion, bounded only by indeterminate standards or lists of factors that may be considered. Like, there's a template, this is the kind of assets should be filed. This is how we go about this. So these are very broad guidelines that the legislature has given the family court. A lot of people criticize this a lot. A lot of people don't like it. They say the rules are too vague. I've had clients coming and telling me, what divorce? There are no rules. Anything happens, that person got the child, that person didn't get the child, I got the flat. They don't understand that. It's on the facts. It's true that vague rules increase the likelihood that the nature of the judge, the court, or the community may affect the outcome of the case. Of course, we are human. Even judges, although some think they are not, little above, but judges are after all human. What they think is going to cloud their judgments. With deepest respect I'm saying this, but that's a fact for anyone in any station of life. So, many litigations who want to settle their disputes in the form of rules are dissatisfied. They are unsure. They are saying, what will be the outcome? Any divorce lawyer will tell you, first thing they come and say, what will happen? What will they say? It can go either way. You cannot decide. And as a divorce lawyer, I would also say this, that we only hear one side of the story. We don't know what the truth is. That's for the courts to find. I might be defending a client, but I don't know whether she or he is telling me the truth. Maybe there are things. We keep telling them that no surprises, tell us everything, be honest. But still, there are often times when we are suddenly handed a FIR filed 5 years ago when the husband held a knife to the wife's throat. But he's not told me anything about it. Anyway, when the results of litigation is uncertain, parties are dependent upon the expertise of lawyers and become vulnerable to strong-arm negotiation tactics. Which is why we are always searching for the Ram Jethmalanis and the bigger lawyers and the more expensive lawyers. There's a theory that the more expensive the lawyer is, the better he is. Which I disagree with. Anyway, this, in my opinion, is exactly where the family court has an advantage over other matrimonial courts because of Section 13. Advocates are not, as a rule, allowed to appear.
In West Bengal, I have
I've heard, yes.
What?
that routinely
They go.
advocates are allowed to appear in the court.
Are they allowed or do they seek permission? Actually, advocates, I think, advise the clients that I've never appeared in a family court and I've never referred anyone to family court. So I really wouldn't know, but what I've heard is, what happens is they go to a lawyer and then it is seen that the jurisdiction falls within family court, and then Either the lawyer advises or the party decides, the petitioner decides that maybe I can't do this on my own, so they apply for permission to have a lawyer present.
One of my relatives, he had to file a divorce in one of the districts of West Bengal, and I was told by him, I am a family court judge, I was told by him, compulsorily the judge asks for a lawyer. And I say, it is a family court, how will you?
It's a family court.
Yes. I will not name
I'm surprised. No, I don't need the name, but I'm really surprised because district courts, yes.
I know, because for the fact it was my cousin, and I am telling him, you just draft it, only you just have to draft and present it to the court, and he tells me, no, the judge mandatorily asks for the advocate. That is, and I'm,
That's very unfortunate.
and I'm like, what?
I really wasn't aware of
The
this.
bar has pressurized it.
Maybe the bar has pressurized. I have too many lawyers. Have you seen lawyers? Ooh, too many of them. So obviously, not enough work. Litigation is on the down, especially corporate, and so it's become a rat race out there. Anyway, as you all know, Section 13 does not impose a complete bar. You can take the assistance of a legal expert or allow a party to have a. As I was saying, much to the grievance of the legal practitioners, but I feel legal practitioners should not be allowed unless the reconciliation completely fails or the judge finds that there is just no solution.
But I beg to differ a little bit here, because then I found some counsels, some lawyers who, honestly, in family court cases, I've seen them coming to a compromise, trying to negotiate things.
Yes, some of them do, but some of them just increase the
Yes.
level of acrimony. Like I've had this experience, I was trying to remember, when I've been approached by I'm trying to settle the matter, appearing for a wife, and I've been approached by the advocate of the husband saying, why are you doing this? Let's just do a few more appearances, get some more fees, then we'll settle. You file for 13 under section 13 and then later we'll convert it to 13B. I said, why? This happens. Anyway, no names taken. Okay. Judges usually keep an open mind in family courts. I hope. Means I'm hoping, after hearing what you said, I don't know. I'm really distressed to hear that about the other state. Anyway, judges respond to precedents, the informal norms of the courthouse, boundaries of law. You will think within these parameters, so judicial discretion is unlikely to go beyond that. It is rare that suddenly, like the tribes, you're stuck in that box because of the tribes. You won't suddenly decide, okay, I will supersede everything, overreach the law and put tribes through here. So I think this discretion is justified. As we see, family law is not so simple. It's not a corporate case, not a criminal litigation that, you do something and the result is that. You go to jail, you go wherever, or something follows something. It's not like that. This, I think we've established. There's a clash of values, there's a chaos from the change that happens, the children are affected, the new legal standards, everything. It's a whole thing. So what should be the focus? What needs to change? This is an important thing. Firstly, the laws or the results of the judicial decisions need to be made uniform. I already said this. To some extent, to enforce gender equality and prevent abuse. There is too much discrepancy and confusion in personal laws. We've seen that. And the grounds of divorce have to be made not only uniform but also gender neutral. At present in India, only in Hindu law they are. In fact, in the Divorce Act is an Act of 1880 something. We are in 2024. I think we need to.
Thankfully, it is not enforced here.
You are lucky, but these laws have become archaic. In fact, even that restitution of conjugal rights, it was withdrawn by the UK government, but the British thought it a very nice thing to impose on us. It was there before the Act of 72 came in, the Special Marriage Act came in. Next, the whole process of taking a divorce should be made simpler, taboo-free and approachable for the masses. More than that, the approach, mentality and point of view has to change. This, I feel, is a bigger problem than the law. Why? Two people having a divorce is no one else's business. No one else's. Indians but love to sit, gossip, sit on a high chair, tell them, give them unsolicited advice. Everyone thinks the marriage can be saved. The old uncle, the grandfather, they will all come and say, no, beta, don't divorce. Ye hoga, wo hoga. It doesn't work that way. Then the approach of mediators and counselors in marital disputes are often regressive. They go by the old ways of thinking. They are not open to new ideas, and these days there are so many new things happening. They don't move with the time so much. They give unsolicited advice and pry into the personal lives of the parties, which is outside their domain. I think they need to be trained further. Sometimes they ask really personal questions which may be done without. I've seen a few conscripts of questions asked by counselors, and some of them not required. They should have a, if the answer is yes, then ask, otherwise don't. But they go on asking like it's a questionnaire. And then one more thing we have to realize is counselors, when they are required to give a failure report to the court, stating reasons why they failed. If the couple has decided to divorce, it's not the counselor's failure. We have to understand it's a failure of the marriage. Sometimes divorce is inevitable and sometimes not. It cannot be solved amicably. Sometimes we have to accept that. As a society, trying to preserve the marriage of institution is a silly thing. Because some marriages are just irretrievable. Our mentality to divorce, it's still primitive. We still think it's taboo. It's better. It's better than before. Nowadays, too many divorces happening for us not to accept it and move on. In fact, the opposite is true, because people are very quickly taking a divorce. They marry in haste and divorce in more haste. Ironically, nowadays, the fancier the wedding I go to, I find myself thinking, how long till they come? We've become cynical. Yes. And the fancier the wedding, the earlier the divorce. Because nowadays, if you the standards of proving cruelty in India is so high. Unless no one thinks like absence of love, absence of care, non-satisfying sex, dissatisfaction in the marriage, these are too trivial to be considered grounds of divorce. That needs to change. These are issues that both men and women face, but they are forced to live together. It's not a ground for divorce. So they make up a story. They cook up a story that See, he beat me. Plus, another issue is there's so much ignorance surrounding sex. There are people who are just not attracted to each other or compatible, but cannot state the reason. They are forced to allege that the other is infertile. They go to court and say he's infertile. My own cousin had to face this, which is very different from I can't have sex because I don't like you. I don't feel attracted to you. They should be able to say that. Everyone jumps and asks, why did you get married then? Okay. Unfortunate reality of arranged Indian marriage is that people leave it to their fate that their sex life will be satisfactory. They think, oh, they'll get married. 1 year down the line, they'll start producing babies. Money. Most people don't realize that just because you find each other good looking or your families go back a long way doesn't mean you're sexually compatible. Most people don't know themselves when they marry. Knowing all this before marriage is impossible, and then the question, why did you marry then, is a little past reality. Another problem, people need to mature. It's not just the system that needs to mature, it's people. Most people I know would rather fight and spend money on lawyers than come to an amicable settlement. Most people are vindictive and lack the courage or the bigness of the heart to let go. Okay, chalo, chhod diya. Nahi. They want to fight. This is because divorce is considered a huge taboo. So much so that they feel their entire life is wasted. Since this is the amount I am suffering, you have to suffer it too. That's Saas-Bahu syndrome. Typical. Divorce isn't the end of life, and their lives would be better if they cut short years of fighting in courts and focus on rebuilding themselves. So, sometimes there's no other option, just give them the divorce. As quoted from, there's a book, Fly Away Home by Jennifer Weiner. She's written, divorce is not such a tragedy. A tragedy is staying in an unhappy marriage, teaching your children the wrong things about love. Nobody ever died of a divorce. Unfortunately, what's the word I'm looking for? Makers of the laws who believe in the institution of divorce do not consider these factors, that not every case can be solved. It is well settled that a family court may receive evidence, any report, any evidence, anything. You are aware of that, any form, and you are not guided by the principles of the Evidence Act. Even there is no strict proof of the document. So I won't divulge on that. So, and I am not going to ask you about the key procedures or process of filing because you are well aware and familiar with that. So there goes 3 pages of my notes. Anyway, one very important thing to remember by presiding officers is that since advocates are not allowed to represent parties have to represent themselves. I'm sure you've seen, no matter how many lawyer friends or advisors they have, for most people, 99.9% people, a courtroom is a very intimidating place. They feel frightened. They feel speechless. They are scared. It seems like, and all those black coats and all we run around in, people feel lost and even uncomfortable. So there are factors which causes this stress. Some of them are being called to the witness box on multiple occasions. You keep calling them back. It distresses them further. Delays, adjournments, they don't understand why suddenly the bar is striking today. Or we've decided not to attend. having to testify multiple times, as I said, protracted court proceedings, it goes on and on. Fear of public exposure, they don't want to be seen having to depose in court. Lack of understanding of complex legal procedures, that's where the judge needs to actually sit them down and break it up and explain. Then face-to-face contact with the other side or the parent, that's frightening. You stand in court, you are a victim of domestic abuse. How many of you will be able to look your husband in the eye and your husband is glaring at you from there? How many of you will be able to say yes? It's frightening for most people. Maybe I'll be able to say it, you will, but most people will not. Lack of support. Many of these people who come, their family doesn't support them, they don't have anyone on their side. Worry about not being believed, especially when there's no one else to testify except herself or himself. This is a real fear. A lot of people really say that I have no proof, it's just my word against theirs. That is something that really worries people. In such cases, I think maybe the court should consider giving them legal assistance. Either legal assistance or at least counseling so that they are better able to address the issue. Plus, the court should ensure that the proceedings are conducted in a language that is simple. Interpretations are given in a language they understand. The questions asked should be simple, not long-winded, then it can be rephrased. And if they have any disabilities or special individual needs, those should be provided. And then holding closed sessions if required. If it is a victim of child abuse, I would also say, go to the extent of saying, if the abuser, accused is in court, take the child to another room, videograph it, give it to the husband or accused person, so that the child is free to speak and and they also know what was said. Then timing of evidence, it's all in the rules, I'm sure. And holding the proceedings in camera if required. We do that a lot. Okay. Questioning of witnesses, I won't go into that. You all are familiar with that. Execution of a decree. I have one thing to say about the taboo bit. Earlier, true marriages were rare. Now it is much more common. But I will tell you about one of my own experiences. I was still a law student, and a very close friend of my mother's, her daughter got married. We went to the wedding. It was in the middle of in a village far interior, West Bengal. When the girl got married, it was all very nice. Her mother was paying dowry. It was full of ideals. I said, what dowry? But those days it was paid. I'm talking about 90s, 89, 90. Were you born then? No. Anyway, so bride went off. After I graduated, I came back and her mother was frantically calling me that they sent her back. Why? Because they want more dowry. So I told her, whatever else you do, don't send her back. And she said, no, I have to send her back. What will people say? I said, who cares about what people say? It's your daughter, don't send her back. I begged with her. They sent her back. She was a victim of bride burning. It's very sad. But that is how far things go. And that's where we come in and we can reassure them, and the courts can be a little proactive and pass necessary orders, even restrictive orders, to protect these witnesses, these women, these victims. I know no one knows what will happen. If a person is really intent on throwing acid in my face, he will find a way to do it. I know, but we can try to prevent it. 1st February 2024, Supreme Court has passed an order, judgment in a matrimony and appeal under section 19 from orders passed by a family court in respect of execution of maintenance orders. This is Mohit, Mohit Anand versus Parul Anand. First February 2024. If you want, I can share it. If you give me your email or whatever, I have it here. Paragraph 20 onwards, the division bench has extensively analyzed the law with regard to enforcement of the same, and extensively discussed section 18 of the Family Courts Act and considered several judgments in relation to the procedure under the Civil Code, the Procedure Code for civil imprisonment in default of payment of money decree. I had planned to read out the paragraph 27 onwards, but I think if I share the judgment, it will be better if you can go through it at your own pace. Ultimately, they held that in this case, what had happened is the husband, because he was not paying maintenance, he was sent to civil custody on multiple occasions, civil imprisonment. Ultimately, the Supreme Court held that it is wrong, maximum 3 months, and you can't keep sending him back. There are other remedies to be followed for ensuring payment. So just have a look at it, I would suggest. If you want, I can read it out, but I think it's better if, since it's a recent judgment, that apart, there are few other judgments in recent years. Irretrievable breakdown of marriage. One is Silpa Shailesh versus Varun Srinivasan. A 5-judge constitution bench held that the Supreme Court has the power to dissolve a marriage on the ground of irretrievable breakdown of marriage under Article 142(1) of the Constitution. The Supreme Court directly, without following the procedural requirement of a motion. In the case, the parties married on 12th of December 2026 and separated after 4 years without birth of any child. While the divorce proceeding was initiated by the husband, the wife's father had initiated criminal cases against the husband for under section 498A, 323 and 354. Apart from this, the wife herself had filed a maintenance case under 125, which was pending. Though both parties had taken the stand that they wanted a settlement through mediation, and the matter was referred to the Supreme Court Mediation Center, the mediation remained unsuccessful. No agreement could be reached. Thereafter, on that ground, they wanted a mutual consent, but they couldn't agree on the alimony. So Supreme Court held they can themselves direct the alimony and pass the necessary order. Next is do you have these citations? Or you have the cases? I have it here. Then about the adoption rules. Debaroti Nandi versus Tripti Gurha. These are all unreported, most of them. I have them all. If you want, I can email them all to you. This held that couples with 2 or more children cannot choose a child during adoption, and the adoption regulations apply retrospectively. The right to adopt cannot be raised to the status of a fundamental right within Article 21, nor can it be raised to a level granting prospective adoptive parents the right to demand their choice of who to adopt. There were some parents with 2 biological children and wishing to adopt a third. These petitions, they challenge the decision of the Central Adoption Research Authority, that's CARA. Do you get any adoption cases here? I'm sure. CARA that affirmed the retrospective application of the adoptions regulations. This court, the Supreme Court held that the court can take judicial notice of the fact that there are a number of childless couples and parents with 1 child who are adopting 1 more child and will adopt a normal child, whereas the chances of a specially abled child being adopted is remote. Generally, no one wants a specially able child. This policy has been brought in only to ensure that specially able children are adopted. Next, can family courts hear domestic violence cases? In Roshan Shah versus Nishigandha Shah, Bombay High Court has held that yes, can be transferred an application under the Divorce Act before the magistrate can be transferred to a family court under section 24 of CPC. Next, Ujaswa Pathak, constitutionality of restitution of conjugal rights pending a divorce proceeding. We are back to the controversial stuff. Hindu Marriage Act, Special Marriage Act, Code of Civil Procedure together provide for restitution of conjugal rights. If a spouse withdraws from another under the first 2 laws, they can go to court and seek return of spouse. We all understand what restitution means. Such a court order is enforced to the provisions of the CPC. The petitioners in this case, in this particular case, Ujaswa Pathak, students from the Gujarat National Law University, have challenged the constitutionality of this legal framework that governs restitution of conjugal rights. They claim it violates the constitutional rights to life, equality and non-discrimination. The court is pending decision if this is indeed the case. The petition refers to the findings of a committee formed by the Ministry of Women and Child Development on the status of women and children. The committee has noted that the main focus of the framework around conjugal rights was to preserve the integrity of family. But there are multiple cases that show that since then it has been misused to deny women's claims for maintenance or for cruelty. In fact, it has propagated more cruelty, I would say. The committee suggested that the deletions of the provisions related to restitution of conjugal rights, as it no longer serves the best interests of the family. This case discusses those, but at the same time, Delhi High Court and Tripura High Court have held that mere presence of a decree of restitution does not disentitle a wife to ask for maintenance. Maybe so, but that would be worse in my humble submission. Because not only are you forced to live with him, you take his money. Money is never a compensation for loss of moral dignity or human dignity. That's never a compensation. Anyway. Any questions before I close? Do you agree about the restitution, that it is an archaic law and it needs to go?
Yes.
nowadays the world is changing so much. I think we need to be progressive, not regressive. If you have no further questions, may I close? Yeah. Very ably assisted by Anuka here. In this short time, I have tried to encapsulate a large and extensive field of law, as you are well aware, that is forever changing and evolving, even now as we are speaking. One never knows when or where the ugly faces of divorce or abuse will raise their ugly heads. It is not possible. Surprisingly, it turns up everywhere. But we can guide them as we are guided by them. It can be our endeavor to help and assist. I believe that there is much to learn from the younger generations as they can learn from us. There are no lines between good and evil. Everything blurs at a point. Everyone has a right to a point of view. In an ideal world, everyone would live and let live, be in peace and harmony, but it is not an ideal world. For as long as humans will walk this earth, there will always be hate and distress, and violence and abuse. But there will also be love and peace, and hope and kindness. To demonstrate, please be patient with me for a minute and allow me to read a favorite poem of mine by an American poet, Maggie Smith. I love this. I hope you read light poetry. In any case, I'm making you listen to this. Good Bones by Maggie Smith. Life is short, though I keep this from my children. Life is short, and I've shortened mine in 1,000 delicious ill-advised ways. 1,000 deliciously ill-advised ways I will keep from my children. The world is at least 50% terrible, and that's a conservative estimate, though I keep this from my children. For every bird, there is a stone thrown at a bird. For every loved child, a child broken, bagged, sunk in a lake. Life is short and the world is at least half terrible. And for every kind stranger, there is one who would break you. But I keep this from my children. I'm trying to sell them the world. Any decent realtor walking you through a real shithole chirps on about good bones. This place could be beautiful, right? You could make this place beautiful. Let's do our best then. Thank you so much for listening to me. If you need the references of any of the judgments, please come to us. We will assist you.